Yo, busia for mo bibia kwa ba shonko so ba FunnTV GH be short sa afi no abadwumadi so a obe like obe share no one subscribe but notification button bell no so but adoma no se ne ya new political updated videos bia won sabe to me akebi be short say obe share ma for insa ebe to me akebi se ne ya omo ne yedi dwumai and ye call highway no so na ensem pi ensem ne bi ni sen ebi ni se Kelvin Taylor asa akofa ba biu okofa ba wan ho asema a chief of justice at this respect high court for now at this respect your big time arrow some pa abusia for arrow pa say supreme court judges no say omumbu high court ko ni bi enkofa mra ni na ejina afenyo makin case e ba ya o de kwa no de ba so want no wa say o ye say chief of justice so really no say no o ye NPP ni a o dima NPP for no wa court disrespect high court for abusia information bo say mo me akọ ni akọ tie sa video me da mo say
or say if Afenyomakin had gone to the high court would have still come to them for interpretation. Alban Bagbin lawyers no raise the issue no. Omo can be said. In fact, so we read the constitution no. Now who follow constitution no. Now person who didn't cry. Nanka or say Afenyomakin a high court. But Afenyomakin ended up at the Supreme Court. The application from the speaker, lawyers, say it is not right for Afenyomakin to even, at the end of the day, come straight to the Supreme Court. Even though the Supreme Court oversees or is powerful than the High Court, we should all follow due process. As far as the Constitution is saying, there is the room, we still have an option to use. Afenyomakin was supposed to use that option. Because in Ghana, you name says Supreme Court as such a High Court. But the Constitution so says Supreme Court such a High Court. But the Constitution also insisted say it was say issues like this, majority of them has to come to the High Court. The Constitution recognizes the Supreme Court as being the the highest court of the land. But the Constitution also did not. The Constitution also did not discredit the High Court. It gave the High Court specific role to play in issues like this because Constitution will say due process is very important when it comes to law. Into a case, even though the Supreme Court is there, you have to go to the High Court first. So why did Afenyomakin come to the Supreme Court? Chief Justice started using hypothetical statement in her ruling. Now, when a Chief Justice sits in the Supreme Court and starts using hypotheticals, because the probability say Afenyomakin echo High Court or Beba Supreme Court, you cannot say it is definite. No. The probability say case, it could have ended up in the High Court, it is also high. So how can a Chief Justice sit in the Supreme Court and say, if even Afenyomakin had gone to the High Court, it could have still ended up on her table. It means the Chief Justice sits in the Supreme Court using hypothetical statements to judge a case that are supposed to go through due process and definite actions. Now, listen to this.
Third, it is the most basic tenet of our legal system that different courts operate different jurisdictions. And every court is given its own jurisdiction. So the type of cases that can be settled in any court depends on the nature of the dispute. Thus, if someone is challenging that a member of parliament has not lawfully won their seat, that challenge must be done at the High Court in the region that the constituency is in. However, if any two people challenge that the process of electing the same member of parliament did not conform with the constitutional provision, that dispute over the correct interpretation or meaning of the constitutional provision must be brought to the Supreme Court for interpretation. Indeed, if the dispute over correct interpretation or meaning of the relevant provision occurs while the parties are before the High Court must, by direction of Article 132, stop hearing the case and refer the dispute over the correct interpretation of the Constitution to the Supreme Court. There are many cases on this manner of resolving disputes requiring constitutional interpretation, including ex parte senator rulings. Citation provided. In every given month and year, the Supreme Court regularly deals with cases seeking interpretation and enforcement of provisions of the 1992 Constitution. And every law report issued every month is filled with such cases. It is therefore misinformation and misapprehension of law for the applicant to present that the Supreme Court has no jurisdiction to provide the correct interpretation of Article 97(1)(g), because Article 99 gives jurisdiction over determination of membership of Parliament to the High Court. Article 99 reads, "The High Court shall have jurisdiction to hear and determine whether elected as a member of Parliament or the seat of a member has become vacant, or a person has been validly elected as a Speaker of Parliament, or having been so elected has vacated the office of Speaker. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal." From the above, it can be seen that if anyone raised the question whether a person has been validly elected as a member of Parliament or a seat of a member of Parliament has become vacant as a matter of fact, that person is required to go to the High Court for the High Court to resolve any issues around that question. In the instant case, the records brought to the Supreme Court submitted that the question was raised on the floor of Parliament that by filing nominations to contest as independent members of the 9th Parliament, members of the 8th Parliament should be deemed by reason of the meaning of Article 97(1)(g) to have vacated their seats in the 8th Parliament. Thus, the vacation of seats is not a matter of fact from death or resignation or notice by the parties themselves to Parliament. It is to be taken from an interpretation and enforcement of Article 97(1)(g) the Speaker, or G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member, or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2. Notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original or political party forms part shall not affect the status of any member of Parliament. Now clearly, with the disputed interpretations alleged in the plaintiff statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rollins, to refer these contested meanings to the Supreme Court to determine the correct interpretation. The plaintiff statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rollins, to refer these contested meanings to the Supreme Court to determine the correct interpretation. Even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rollins, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and a Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself. Correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself.
So you see what she tried doing here? She tried to override the power of the High Court because she wanted to take over the case. She knows that if Afenyomakin had entered the High Court, the outcome that Afenyomakin is getting at the Supreme Court, he wasn't going to get. Because when you look at the jurisdictions of these courts, the High Court has original jurisdiction and the Supreme Court has referral jurisdiction. Meaning, there's a reason why the High Court has original jurisdiction and the Supreme Court has a referral. That is why it was very imperative for the Supreme Court to send Afenyomakin back to the High Court for him to exhaust the process there, and that when the process is being exhausted, it can come to the referral.
Abusuafo ye draw file to sumi enu me show mo say ma bro fi say mo me ya to aso ahwe me show so one like so like na on share so a wa share ma for inside to me akebi jumani ma ide yi pa Chief of Justice said the High Court for atem wa didi omo atem big time wa didi omo atem ma na ya ro yi pa High Court for no so ara ho a omo so ye omo nti omo aso crazy see am dey ka ko ide and ha Chief of Justice to bet me losing the seat abusuafo me show mo say mo ba me akọ to aso,
which is the Supreme Court. But in this case, the Chief Justice sits in her chair and tells Ghanaians that forget the High Court. There is no importance to the High Court. It does not have any role. In fact, we as the Supreme Court, we can override whatever the High Court does. Then from the Chief Justice hypothetical statement, whatever goes to the High Court, the Chief Justice from the Supreme Court can just enter the High Court and say bring it to the Supreme Court. Then it means the Constitution that created the High Court, at the end of the day, the same Chief Justice is undermining the powers of the High Court. So if you're a High Court judge today, your Chief Justice sits in the Supreme Court and says that no matter what, a case can come there, and if she wants that case to come to the Supreme Court, she can quash the powers of the High Court and bring it to the Supreme Court. But there's a reason why the Constitution actually decided to bring a High Court, brings an appeal court before a Supreme Court. Because when due process is followed, then you get to know the real facts of a case. There's a reason why when the issue of parliamentarians and all that came up, it did not directly, or the Constitution did not directly say go to the Supreme Court. It said go to the High Court, because the case needs to be started originally so that we will know. Because you see, the draft that Afenyomakin took to the Supreme Court, if Afenyomakin had sent the draft to the High Court would have referred Afenyomakin, or would have sent Afenyomakin back to Parliament to present the endorsed proceedings. But because the Chief Justice was in a rush, the Chief Justice wanted to go against the process. The Chief Justice does not respect due process. She basically wrote Afenyomakin's application for him, gave it to him and said, bring it to me, and that I will make sure you get a ruling. That is why we are here today. So the Chief Justice is writing his own application and answering his own application and giving ruling on his own application. As we sit here, the Chief Justice of Ghana today is undermining courts in Ghana from her own hypothetical statement. How can you sit in the Supreme Court and make hypothetical statement that if the case had gone to the High Court, it would have come to you? You don't know. You never know. Because maybe if the case had gone to the High Court, it wouldn't have been an ex parte case. So how do you know that when the case goes to the High Court, it has to come to you? The Chief Justice of Ghana, Madam Tokorno Osnomame, today sits in Supreme Court and undermines the High Court and tells us that even though the Constitution gives the High Court the mandate to oversee these issues, she does not respect the High Court, all because she's there to work for Afenyomakin and Ekufuado. That is the problem of the day. That is our problem as a nation. And you see, this is what they are doing, and this is part of the reason why today, that is why today in Ghana, we are all saying our democracy has been hijacked. Eye kebi mami kebi no yebetimu waka bibi so afa eye peace ye hia yekoto abe ya manfo say eye NDC ne pipi nkwanko sign peace pact no so ne de eye asumdwe no pe peace pact no enye political parties nkwa there are other agencies amu nyina ka ho na asumdwe ne ba ebi ti se Ghana Police Service or some sign peace pact ni eye the Chief Justice herself, because when the election entered up at the Supreme Court yehu de omaye pen senia omadan dan yasem akọ UK akọ for black book bi American semi Ghana for so ada Ghana for. So it's very important to say the judiciary, led by the Chief Justice, almost be signing peace pact. No maybe to say a Juma, maybe a review of the Constitution. So John Evans Atamos start here, and I say they're not Sibio and who here say intent to be personal or so bad. And Minimana on the Ghana for Unabishia, I didn't hear say person in not the Sibio more Dino in my Satanasi in Yabutre, into John Mahama, a bar was a Ghana for Women's National Bank, a year 24-hour economy, and that would see a insane name. When he said he has rehashed them, he has revisited them, he has reassured Ghanaians. And I Brunum and I say, as Anthony Becker said, was a Etimudian or Trust or ye Penini, or ye Oman Peninia, save your own tax row. So Oman Penini, and I say Penini doing MPC or Becano Cratchera, the regional stage or Sa or acted to say or you're stupid on Cano Cre. They be an Adrian say, you're Bassinipa, and I say you hide the much shelter and the bed down more to Abama. But Penina, Nagin Wufia, Obu, Obu Agni, or Bessa Obu Ghana, or Sawa, Libya, or Saba, no, a big team actually will say, a bow and I'm sure, we will fear, it remember was so real fee. If you say seminar to me now, and I'm a little bit so, I was so tiny, Namis me, the human amount. And the John Mahama actually the lead, watch how committed he is, watch how patriotic he is, and how ready he is to serve Mother Ghana. Posters, remember, you're causing my team, they are working on it. You bet to cut videos, not in the Ghana for Atiasia. And you bring in Sembibri or in St. Paulo, in St. Pele. Thank you very much to the Ghost team on Loud Talents TV, in Koto, Free Mind, Ransford Kebuachi, and the other guys who have been running through the TV. Also supported this production to make sure say TV is constantly one of the best TVs in Africa. In fact, in Ghana, we are ranked #1 because every single thing you need, educative programs are Sibu Ekulagni AC in our Paso, programs are Sibu Akroma Photo, any programs are Sibu Ghana, ordinary Ghanaian engineering CNN, Al Jazeera, BBC, current movies about current affairs issues worldwide, national.
For I had a bit manubesi, made obi be out me as a video way. I say, make sure also about notification bell, no so not me that was so what me say you may area, Madam Massey, Macram.